In the previous lesson, we talked about the disposition of inequitable interests when we talk about the subsisting of or already existing interests in trusts and the formalities that are required therein. This is obviously with reference to Section 53(1)(c) of the Law of Property Act. This lesson is going to talk about the Vandervell exception to these rules, and really, this is a good illustration that hopefully gives you a better understanding of this area of the law. Because even though the Vandervell exception is, in and of itself, quite convoluted and quite complicated, it at least gives us quite a lot of room of discussion for really what this topic is telling us. So, this lesson is going to consider an interesting case which examines an exception to the ordinary course of Section 53(1) when we talk about the transfer of title. It comes from the case of Vandervell versus the IRC. There's a couple of cases that relate to this, and we'll get to both of them in this lesson. And as I've mentioned in the previous video, and as I will mention here one more time, this case is quite complex. There's quite a lot of legal argumentation here. Don't feel bad about not understanding it straight away. Really, this is one of the most difficult areas of trusts, and then from here it's quite downhill. Okay, we'll do charitable trusts next, which is a lot nicer. And fundamentally, it's we'll get to a nice takeaway from this point. From this case at the end of this lesson, but fundamentally it is a nice useful illustration of why you shouldn't be just establishing various different complicated legal and trust-based relationships for the purposes of maneuvering out of tax liabilities without first consulting an expert tax advisor to see what potential liabilities may exist. That is essentially the takeaway from at least the moral lesson or the practical lesson that you can take from this particular case. So the case comes from 1967, the case of Vandervell versus the IRC. In this case, 100,000 shares in Vandervell Products Limited had been held on a bare trust for a certain Mr. Vandervell. I don't know if it's Vandervell or Vandervell. It's spelled Vandervell, so I'm gonna pronounce it Vandervell. In 1958, the bank holding these shares was the National Provincial Bank, and they were instructed by Mr. Vandervell to transfer the shares to the Royal College of Surgeons. This was for the purpose of financing a new chair of pharmacology. What this would amount to in terms of cash money was around £150,000 in dividends, which were then payable on those shares. Again, this is some potentially corporate finance related stuff that you don't necessarily need to have a great understanding or detail of. If you do company law, then you might understand it a little bit better. If you do a specific module on corporate finance, if you're lucky enough to have that particular option, then you might understand it as well. But for those of you who don't do corporate finance or company law, you don't have to get into too much of the weeds into the particular facts. But it's just useful as a nice illustration of what's going on. What was included in this transfer was an option on the part of Vandervell Trustees Limited for repurchase. So they had the option to repurchase those shares to Vandervell Trustees Limited for around £5,000. And what this therefore represented was the idea that the transfer was not unconditional. It was not an unconditional transfer because there was a condition. There was the option to transfer, or at least the option for repurchase, of those shares to Vandervell Trustees Limited. Vandervell Trustees Limited was a trust fund which was set up by Mr. Vandervell, or for Mr. Vandervell, specifically for the benefit of his children. So we have quite a complicated situation here. So we have 100,000 shares being held on bare trust for Mr. Vandervell. The bank holding these shares were then instructed to transfer those shares to the Royal College of Surgeons for the financing of a chair in pharmacology. This represented around £150,000 in dividends. But within this transfer, included in this transfer, was an option for repurchase, whereby Mr. Vandervell had the ability to transfer that property to Vandervell Trustees Limited for around £5,000. And this Trustees Limited was essentially a trust fund that was set up for the benefit of his children. When Inland Revenue then sought payment by way of stamp duty, they utilised two argumentations for why there was a liability in terms of stamp duty in relation to this. And again, if you don't understand the potential tax implications, or you haven't studied tax law, or there isn't an option for you to study tax law at your university, again, don't feel bad. Don't necessarily have to get into the weeds of what stamp duty is and all the various different ways in which stamp duty and inland revenue actually come about, utilising the ability to make arguments for liabilities in tax. All that you need to know is that inland revenue sought to get a payment by way of stamp duty, and they argued this in two ways. The first argument was that the transfer of the property actually fell into the remit of Section 53(1)(c) of the Law of Property Act of 1925, and so represented ordinary equitable disposition of an equitable interest, and so, as a result of which, would fall into the tax liabilities that were presented therein. The second argument that they tried to present was that since there was this option to repurchase, there was this option for the Mr. Vandervell to repurchase this property under Vandervell Trustees Limited, it essentially meant that Mr. Vandervell had retained some equitable interest in those shares, and so as a result of which it cannot be considered to be an unconditional transfer. So let's deal with both of these arguments one at a time. Argument 1, the idea that it fell within the remit of Section 53(1)(c) of the Law of Property Act. If you need to familiarise yourself with that, go back to the previous lesson where we look at Section 51(3)(c). Essentially, what Inland Revenue argued was that there was no written disposition to satisfy Section 53(1)(c) of the legislation, and as a result of which there had been a failure to dispose of the equitable interest in those shares. Mr. Vandervell had failed to, and therefore retained that equitable interest. And if this was the case, they would have to pay. They'd have to pay surtax on the dividends that were then presented, and therefore that were therefore payable. The law lords actually rejected this line of argumentation, noting that on the facts, both legal and equitable interest in those shares had been transferred at the same time. So you cannot argue, Inland Revenue could not argue that there had been a failure on the part of Mr. Vandervell to dispose the equitable interest in those shares. So there wasn't the argument that they had to pay surtax on those dividends as a result of this particular line of argumentation. According to Lord Donovan at 317, if owning the entire estate, legal and beneficial, in a piece of property, and desiring to transfer that entire interest to another, I do so by means of a disposition which ex facie deals only with the legal estate, it would be ridiculous to argue that Section 53(1)(c) has not been complied with, and that therefore the legal alone has passed. That's essentially what has happened here. That, on account of all of the facts of the particular case, it would make no sense to suggest that only the legal transfer has taken place in terms of title, and that Mr. Vandervell retained equitable interest by way of not completing the disposition. They completed the disposition. So argument 1 for Inland Revenue failed. Argument 2 from Inland Revenue was this idea of the repurchase option. Mr. Vandervell, if you remember, had the option to repurchase those shares, and if they did so, they would repurchase those shares under Vandervell Trustees Limited, which would then lead to the creation of a trust fund for their children, or at least it was already created, but it would essentially fill the trust fund for their children. This was an argument that was accepted by the House of Lords, the argument being that, given the fact that there was a repurchase option, that Mr. Vandervell had actually retained a certain amount of equitable interest in the title because of this repurchase option. This was the argument that there has been a failure on the part of Mr. Vandervell to completely divest himself of his equitable interest, owing to the fact that this option to repurchase the shares for the trust fund existed. Now, on the facts, it was concluded that Mr. Vandervell was the true grantor of this option, not the College of Pharmacology, the Royal College of Surgeons. So, therefore, it was him that retained equitable interest in the property. He had not been granted an interest in that property by the Royal Society. So this then gives us the second case, the second Vandervell case. So he fails in the first Vandervell case, at least in terms of argument 2. The second Vandervell case was Re Vandervell Trusts, number 2, from 1974, so a few years later. So Mr. Vandervell had, in 1961, instructed his trustees to exercise the repurchase option to take those shares and hold them on trust for his children. So that repurchase option that existed was utilized in 1961, a few years after the 1958 creation, or at least the 1958 dividends that had been established. In order to ensure that he had no equitable interest in the property, to make sure completely that he would not have to pay tax or he would not be liable in tax, and so that there was no equitable interest that he would retain in that property, in 1965, he had executed a deed of release in which all and any of his equitable interests be transferred. So he tried to basically just rid himself of any interest completely in 1965. He would then die in 1967. Rest in peace, Mr. Vandervell. That same year, in 1967, Inland Revenue came knocking on the door again, with a claim for tax on the dividends that had been issued between the execution of the repurchase option and the point at which Mr. Vandervell had actually executed the deed of release. So notice here that Mr. Vandervell had instructed his trustees to exercise the repurchase option in 1961 for those shares to be held on trust for his children. But it wasn't until 1965 that he executed the full deed of release, which would then essentially rid himself of any equitable interest in that title. So between 1961 and 1965, Inland Revenue said, you have to pay tax on dividends for that particular period. You did not release yourself of any equitable interest. We determined already in the previous case that you had an equitable interest owing to the repurchase option. And so when in 1961 you executed the repurchase option, you had to pay tax on those dividends, and you hadn't until until afterwards. Okay, so between 1962 and 1965 there was tax liability. So, this was the argument. The argument was that Mr. Vandervell, poor Mr. Vandervell at this point, who has already died, had not disposed of his equitable interest until 1965, when the deed was released. While favouring the executors at first instance, in fact, the Court of Appeal would actually find against the executors of his will, the executors of Mr. Vandervell's will. They held that when the option to repurchase has been exercised, it created a new valid trust of the shares, for which was in favour of the settlement of his children, of the children of Mr. Vandervell. The creation of this new trust, therefore, required no formalities, since it was not the creation of a trust in land, but and it was not required to be created in writing. So poor Mr. Vandervell actually failed in his second case as well. And really, there are a few takeaways from this particular thing, from this particular series of events. It's a complicated set of cases, and the nature of these decisions comes down to the complex legal manoeuvring which is generally intended for the avoidance of tax. And as I mentioned at the start, the takeaway from this, in the first case, Lord Reed sums it up very, very well. Lord Reed says, quote, "This case provides yet another illustration of the folly of entering into an important transaction of an unusual character without first obtaining expert advice regarding tax liabilities which it may create." This is at part 305, and it really does sum up this entire series of events quite nicely.